We're here for sentencing on a charge of resisting obstructing an officer causing a serious injury, a 15-year felony, guidelines range of 43 to 86 months, and maintaining a high court misdemeanor, maximum 2 years, no guidelines scored on that. Mr. Nightingale, have you had a chance to review the pre-sentence report and recommendations with your client?
I have, Your Honor.
Do you have any additions, corrections, or modifications that would say?
Judge, I would suggest challenge some of the scoring here, particularly as it pertains to OB9 and OB19. I believe that the number of victims for purposes of OB9 should not be considered to be two, considering that anything that Mr. Shamas had done, of course, defense would argue did not place the other officer in any sort of danger of physical harm. Of course, Officer Meyerson was injured as a result of this, but would argue that the other officer was not placed in that sort of same physical danger. No allegations. It sounds like that Mr. Shamas grabbed the other officer in any way, and so we would say that that OB9 should not be scored at 10; it should be scored at 0.
Okay, so let's do one at a time. So we'll hear the prosecutor's response then, Ms. Goodrich, on OB9, number of victims.
Your Honor, he did resist 2 officers, so there would be 2 victims as far as there are no charges. I believe that's probably scored at 10 points.
I think from the description of the offense narrative, as Officer Meyerson is trying to get the defendant out of the vehicle when he refused to exit, he's physically resisting and grabbing her hand and wrist, causing the injury during that struggle, the pain in her hand, and told the defendant to let go of her hand. Says then Officer Gomez then took over trying to get the defendant out of his vehicle. So it was a continuous event occurring as officers are trying to physically extract the defendant from his vehicle because he's refused to do so. And but then that and one of the 2 officers was seriously injured. I think it's certainly reasonable, and by a preponderance, the evidence would find that both of the officers were placed in danger of personal harm and injury due to that situation. So I think OB9 is properly scored at 10 points. So then, Mr. Nightingale, as to OB19.
Thank you, Judge. So as to OB19, that was scored in the PSI at 15. Defense's position would be that Mr. Shamas's actions here did not amount to the threat of force necessary to obstruct this sort of administration of justice here. It certainly wasn't a threat to any sort of penal security, but it's not scored at 25, it's scored at 15 in the PSI. So I think the argument would be that, and I guess, just for the record, I couldn't find a lot of case law on OB19 scored as 15. Particularly, it seems like most of the literature is regarding when it's scored at 25 in a penal institution. But the unpublished decision I did find, it talked about the defendant in that situation, the officer coming to a cabin for a report of suspicious activity, pretty similar to these facts, except a cabin rather than a vehicle, and that the defendant in that case shut the door on that officer's foot and then pushed the officer off the porch. What Mr. Shamas has pled to here is grabbing Officer Meyerson's hand. The defense's position would be that that's not the requisite force or threat of force contemplated by OB19, and so that should not be scored as such. Thank you.
Mr. Goodrich, people's response.
Your Honor, absolutely. That the OB19 should be scored at 15 points. The force used to interfere with Officer Meyerson's lawful duties that day does rise to that 15. She had asked him to get out of the vehicle. He had refused to get out of the vehicle. When she went to assist him out of the vehicle, he grabbed her arm or hand in such a way that even caused her to lose weeks of work after due to the severity of the injury.
OB19 is commonly and properly scored at 10 points when there's any resisting and obstructing police and the administration of their duties, because it's an interference or attempt to interfere with the administration of justice. So had defendant been convicted today for R&O only for failing to exit the vehicle in order to do so, which was a lawful command, that would be scored at 10 points. People v. Passage 277, Mishat 175 in 2007 upheld a score of 15 points where a defendant physically resisted apprehension and arrest from a police officer. And that's what was going on here. He did use force or the threat of force as part of his resisting the and disobeying the lawful commands of law enforcement. So I think there is preponderance of the evidence, and it does satisfy the statutory definition. So OB-19 is properly scored at 15 points. Mr. Nightingale, any other defense challenges to the report?
To the scoring, Your Honor.
Okay. Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor, thank you.
Okay, Mr. Nightingale, anything you want to say on behalf of your client?
Yes, Your Honor, and I apologize. I think that there is one mistake on the report. CFJ 284, it's got count 1. The recommendation is not less than 43 months or not more than 20 years. I believe this is a 15-year maximum felony.
Oh, that's correct. That's correct. That would just be a typo.
Correct.
So, Agent Martin, I know this was not your report, but can you see to it that that is changed? It's on page 2 of the CFJ 145 recommendation, and also on page 2 of the CFJ 284 mistakenly lists a 20-year statutory maximum.
I apologize.
Okay, that's
thank you, Your Honor. So, on behalf of Mr. Shamas here, he comes before the court at 26 years of age. He does have 5 prior felonies, 5 misdemeanors now at this point. As the report indicates, he was convicted of an aggravated assault while in the jail while this case was pending. It would be part of our argument that the statute allows for a discretionary consecutive as in regards to that case. We would ask that the court not make this sentence consecutive to that one because that is not new felony behavior while on bond or while this case is pending trial. He had not been convicted of this yet when he was sentenced on that case at the district court. And so we would argue that he should receive credit for this 226 days in full. Further, Judge, as the report indicates, the counts that he is pled to in this case, count 1, count 2, per the report, could be discretionary consecutive to one another. We would certainly request the court not impose a consecutive sentence here. The 15-year maximum with his guidelines certainly accounts for what we would argue is a proportionate sentence as far as the maintaining is concerned. And so we would ask that the court not institute a consecutive sentence here. Mr. Shamas does have a letter he would like to tender to the court. I provided a copy to Ms. Goodrich this morning. It's a letter that's written by his grandfather. I can get the court a moment to read it.
Yeah, give me a second here. Thank you. Have a chance to review that.
Thank you, Your Honor. I think this letter outlines a lot of the issues that Mr. Shamas has faced as a young child, and then as into his young adulthood here. He's still, as I said, only 26 years of age. He's a very young man. He's obviously got some diagnoses here as outlined in the letter. Of most important note here, I think, is this TBI that his grandfather references as a result of a physical attack from David's father when he was, only 13 months old. It's my understanding that Dave's pretty lucky he didn't die from that, and has caused him some irreparable injury to his brain. Even if he were not to have that TBI, it would still be my position that he's only 26 years old. His brain is just now becoming fully formed. He, other than his criminal history, would be HIDA eligible. Not that the prosecutor would agree to it in this case, certainly, but I think it's something the court should consider as far as the brain science is concerned, that he is still a developing young man. He does have some significant criminal history, but this is, to my knowledge in reviewing his case file, his first allegation of violence towards another human being. I understand that he's got that conviction now out of the jail, but in time, this would be his first crime of violence that I'm seeing. I think that certainly should be considered as well by this court, that this is not sort of repeated behavior of assaulting police officers causing serious injury. Of course, I think David's remorseful for what happened here. I think he intends to give a statement at some point, but I would say that he would probably state that he didn't intend to hurt Officer Meyerson. He certainly intended to grab her hand. I think that both of those things can be true, that although he intentionally grabbed her hand, he did not intentionally hurt her. Although that grabbing did, in fact, hurt her. And of course, he's remorseful for that. When I reviewed the body worn camera again yesterday, this all happens really fast. The officers approach the vehicle, they order him out. He's got a lot of questions about, what's your probable cause to do this? Can I keep recording, et cetera, et cetera. You sort of see the writing on the wall before it happens. And as they're putting him on the ground, you can hear Officer Meyerson say, "Stop grabbing my hand like that." And then she kind of, she makes a noise that I would assume is when her hand was actually hurt. I can't say that definitively, but that's what I'm inferring by the video. Officer Gomez then at that point takes over. Mr. Shamas still has questions about why he's being arrested. I don't think those are ever really answered for him, but nonetheless, he's here accepting responsibility for what he did. I think this is sort of a theme for Mr. Shamas that due to his childhood, due to the fact that he was abused by one of the two people in his life that were supposed to care for him, and abused so bravely that he could have died. When he is encountered with authority figures who he perceives as being abusive, right or wrong, but as he perceives being abusive, he then reacts to that in what I would say is an inappropriate way. And so I would suggest to the court that in order to counter this kind of behavior going forward, of course, the court needs to consider appropriate punishment for this action, right? But he is still such a young man that he is going to enter the community again at some point. And I think the court would be potentially misguided in not at least ordering him to do some sort of CBT or cognitive therapy to try to address what's going on with him. He's obviously got some ADHD that is not being treated, and that certainly, I think, has an effect on his behavior in the real world and in the jail, for what it's worth. There's also a statement in the PSI that Mr. Shamas does not know if his use of methamphetamine and alcohol affected his behavior that night. Of course, Agent Fagan isn't here, but when I talked to Mr. Shamas about that, he thinks that's a misunderstanding. He doesn't remember directly saying that. Of course, Agent Fagan heard what he heard, I'm sure. But I think it would be his position today, Mr. Shamas, that of course his use of methamphetamine and alcohol affected his behavior that night. I don't know any reasonable person that would say if you're high on meth, your behavior is not affected in the real world, particularly when you're interacting with authorities. And so I don't think that that's an accurate statement that he made, or at least not one that he intended to make. Let's put it that way. You can further see, Judge, as the body cam rolls on, that his hands are pretty consistently doing this, even when he's in handcuffs. I mean, he's just grabbing the whole time, and you can hear Officer Meyerson say repeatedly, "Stop grabbing, stop grabbing." All that to say that I don't think, had he not had this TBI, had he not been high on meth and alcohol, had he not had this other negative interactions with these authority figures in his life, I think this incident would have gone much differently. Unfortunately, it did not. And so we're here. We're asking for some leniency. Mr. Shamas's guidelines are what they are, as the court has overruled defense's arguments at this point. But I think a downward departure may and would be appropriate here based on his lack of history regarding this physical crimes of violence, his age, and what's going on with him mentally, Judge. So our request would be to go down from the guidelines here, request some sort of county sanction, limited prison sanction. He has been in prison before, but he also has, successful terms of completing probation. And so I think with therapy, with substance abuse treatment, that he could be successful, just like he was in the past. And so that would be our request at this point. Thank you so much.
Mr. Benke. Mr. Shamas, you don't have to say anything today, but you're allowed to. Is there anything you want to tell me?
Yes, Sean. Nightingale did a great job of describing my feelings, and I'm not the best speaker, but I almost to a degree can't believe that this happened because, like you said, I didn't mean to hurt her at all. In fact, when we came back to the jail, we talked about it. And not to try to garner sympathy, but we talked, and when she told me that her wrist hurt, I broke down crying because I was never a violent person, especially to women, because obviously I grew up with a single mom, and that's just not something I've ever had happen before or wanted, and I just can't believe it happened because it's bad enough that I relapsed at all because I was doing a lot better. I really wished I wish I would have just gone along, even though I really didn't understand what was happening. And I still don't fully understand, like, all the details of my arrest. Probably, I guess, because I was under the influence, fair enough. But it was entirely my fault. I mean, I wish I would have just gone along. I didn't grab her to hurt her. I just didn't understand why she was grabbing me, which I was saying at the time and stuff, but either way, it was my mistake made, and I'm deeply sorry, and I really regret all of this. And I think that's all I can say.
All right, thank you, sir. Ms. Goodrich, close position.
Oh, yeah, Sean, if the court would allow Officer Myerson to make a written statement.
Yes, of course. Officer Myerson.
I would like to thank the court and Your Honor for the opportunity to speak today. As a law enforcement professional, I have an obligation to serve and to protect and to be heightened to the needs of the citizens in my community. For the past 20 years, I have faced each situation with the same professionalism and commitment to adhere to the law in the name of safety for others, safety for my fellow officers, and safety for myself. With great pride, I put on my uniform, I put on my vest and my gun each day. One minor misstep might be the difference between peaceful interaction or injury, and in the most egregious situations, even death. I treat this commitment with the same determined focus and with great respect. There's no room to second guess or be deterred. My interaction with you in April of this year, Mr. Shamas, was no different. That is, until you decided you were above the law. You defied my request to cease emptying the contents of multiple cups onto the parkway. You defied my request to answer questions. You defied my request to exit the vehicle. And ultimately, rather than comply with my request, you chose to physically resist and fight me. That choice you made to fight me resulted in a severe injury to my dominant hand. That choice you made to fight me required surgery for the injury to be repaired and numerous months of painful and restorative physical therapy. That choice you made to fight me left me out of work for 4.5 months with the possibility of never returning. That choice you made to fight me cost me several thousands of dollars of lost wages. That choice you made to fight me left my department and the citizens of my community short an officer during the summer months, the busiest time for our township. That choice you made to fight me resulted in our officers being stretched to cover my absence and cost my department thousands of dollars. That choice you made to fight me is the one and only time I've sustained an injury doing the work I love and I'm driven to do. The choice you made to fight me has left me with chronic pain, at times so severe it wakes me in the middle of the night. The choice you made to fight me has left me second guessing my future ability to defend myself from life's abuse. However, I will not be deterred. My commitment to the work that I do is in the name of sparing my community from likes of individuals such as you. While I forgive you for the mistakes you have made, it does not absolve you, Mr. Shamus, from responsibility and the consequences of those actions or the choices you made that night. My statement in front of the court today is to remind you of just that. Thank you very much, Your Honor.
Thank you, officer. Ms. Goodrich, any recommendations?
Yes, Your Honor, thank you. This incident arose on April 14th of 2025. Defendant was found to have methamphetamine, cocaine, and open alcohol in his vehicle. He engaged with the struggle with Officer Meyerson, as she stated, causing the serious injuries that she explained. The defendant is 26 years old. At 26 years old, he has 5 felonies and 5 misdemeanors. He was 14 years old at the time of his first arrest. After the arrest on this incident, and while incarcerated, he was charged with aggravated assault and also pled to an assault, 2 subsequent charges that were violent in nature. He's already been offered services through 2 times juvenile probation, 3 times adult probation, 4 times he's been incarcerated in a county jail, and 1 time he served prison for 30 months. Defendant has been to an inpatient treatment program and also 3 outpatient counseling programs, with the last one completed as recently as February of 2024. Defendant was paroled out of prison recently on November 29th of 2022. Defendant had left his mother's home because he didn't want to obey the house rules there. He was fortunate to have grandparents that were willing to take him in, and he was even in his grandfather's vehicle at the time of this incident. He chose not to use services that the courts have previously offered him or the support his family has previously offered him. He's unemployed with a 9th grade education. The guidelines are 43 months to 86 months. The recommendation is at the low end of guidelines at 43 months. Due to his violent activity while incarcerated in a jail, while sober, while in a secured environment, it leaves me very concerned for public safety and having him in our community. I would ask the court to consider mid to high guideline range in this case. And as part of the plea agreement, there was a restitution amount that was agreed upon for $6,761.80. Thank you.
Thank you, Ms. Goodrich. Mr. Shamas, if you'd please stand for the court sentence. Well, Mr. Shamas, there's some financial assessments that are the easy part here. There's the restitution of $6,761.80 as agreed in the plea agreement. There's state minimum costs of $136, a crime victims assessment of $130, and the court will assess court costs in the amount of $350. And then in terms of what to do with the incarceration part here, the guidelines are 43 to 86 months. I hope you were listening carefully during Officer Meyerson's statements. As your attorney said, 2 things can be true, and I agree with that. And so, all the things that your lawyer expressed about your life are, true things. And all the things that Officer Meyerson explained are true things. Everybody gets the cards they're dealt in life and through their childhood. And plenty of people who've experienced childhood traumas don't have 5 felonies. So, what happened to you may contribute to some of the things you do, but they don't excuse them. There's a path for you to be a law-abiding person. I'm sure if Officer Meyerson were to tell us the story of her life, there's things that she's probably had to overcome. Every single human being you meet has had to overcome something. And she's given her life to a lifetime of service to the community. And, as a reward for that, she suffered this injury Every officer that goes out every shift knows that something like that or worse could happen to them, and they do it anyway. And maybe reflect on, why do they do that? Why would they do that? And see what answers you can come up with. And if the answers you can come up with are just to hassle people like me, I'd say think some more. I'm troubled by the fact that you have 5 prior felonies, you have a juvenile record. There's been a lot of efforts to try to intervene in your life without success at this point. I'm very troubled by the assaults in the jail. I think one was a conviction and one is still pending. Maybe?
That's correct.
Yeah. So I don't think that low end of the guidelines is a sufficient sentence given your history and given how you've behaved yourself in the jail. Plus, you have a prior conviction for fleeing and eluding the police. So your actions this incident sort of fit a pattern, I think frankly acknowledged by you and your lawyer about your response when authority tries to intervene in your life. But I also have to consider, I don't think this is an upper end of the guidelines case either, because of what your attorney described. And I think there's no indication that you were intentionally trying to inflict an injury. The charge that you're convicted of would be the same charge if you had, for example, been putting the boot to an officer as they lay on the ground. It'd be the same charge. It'd be the same guidelines. So I think I have to leave some room that this is not, among the worst that your behavior could have been. So on the whole, I think taking into account your prior felony history, your prior history of felonies involving police conduct, and your prior prison sentence of 30 months that you got out of Emmett County before, and your post-arrest assaults in the jail, I think a sentence at the midpoint of the guidelines is appropriate. So, Mr. Shamus, I'm going to commit you to the Michigan Department of Corrections for a term of not less than 65 months, nor more than 15 years on count on the R&O injury, with credit for 200 days previously served. I forget the case name, Mr. Nightingale, but I think I'm legally not allowed to give him credit for the time he's serving another sentence. And then on the maintaining a drug vehicle, I'll commit you for 16 months to 2 years with credit for 200 days and run those concurrent. I don't think there's reasons on this record to impose discretionary consecutive sentencing there. So, Mr. Shamas, that is the sentence of the court. If you wish to appeal, you can file an application for leave to appeal. If you wanted a lawyer appointed for you, I would do so, but you'd have to make that request within 6 months of today's date. We're going to hand you a couple pieces of paper about that appeal process and your rights. One of them we're going to ask you to initial right now, so we have a record that we gave it to you. The other one's for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Shamas?
No, but thank you.
Okay, good luck. I can't order you to do CBT in the prison, but there's programming going to be available.
A 26-year-old man stood in court facing sentencing after a violent struggle with police left an officer seriously injured. The incident began when officers asked him to step out of his vehicle, but instead of complying, he resisted. During the struggle, he grabbed an officer's hand and wrist, causing a severe injury that later required surgery and months of recovery. In court, the defense argued that the young man never intended to hurt the officer and pointed to his troubled past, including childhood trauma, addiction issues, and a brain injury from abuse when he was a baby. The defendant himself broke down emotionally, apologizing and admitting he regretted everything that happened. But the injured officer also addressed the court, explaining how the injury changed her life, forcing her into surgery, months away from work, and leaving her with lasting pain. After hearing both sides, the judge acknowledged the defendant's difficult past, but made it clear that past trauma cannot excuse repeated criminal behavior. Considering his long criminal record and the serious injury caused, the judge ultimately sentenced him to 65 months in prison, reminding him that every choice carries consequences.